Hello, I'm Chuck Martin, and welcome to the Voices of the Internet of Things. With me today is Dan Rabinowitz, CEO and founder of Predictive. Dan has been a trial attorney at the U.S. Department of Justice, Associate General Counsel at Booz Allen Hamilton, and CEO of Deco Cocktails. At Predictive, Dan focuses on using artificial intelligence to predict the outcomes of federal lawsuits. Welcome here, Dan.
Oh, thank you, Chuck.
So tell me, we're here because I'm just so intrigued about what you do. Talk about a vertical market. Tell me about what Predictive does.
Sure. So Predicta starts, if you will, where traditional legal research and writing ends. So lawyers, when they're faced with a case, do research on the case law, on the precedent, do deep dive into the facts, and then try to craft arguments and come up with strategies based upon those two large buckets, if you will. But ultimately, they are not going to be the ones deciding whether or not their arguments have merit or how how convincing they are. On the other side of that is a judge, and a very particular judge. And what our analysis has determined is that those judges' decisions are variable. That is, they are highly individualized. Each judge might arrive at a different decision, despite the fact that the facts and the law are exactly the same. So the way to account for that difference between individuals is, if you will, human nature. All of us are affected by a number of things, and we react in different ways to any number of things that we come in contact with. And to go back to what we've studied, our studies have borne out that the things that ultimately most persuade or most influence judges are the actors involved in the case. That is, the parties and the attorneys. And those will ultimately determine how the judge will rule. Let me explain what I mean by attorneys and parties. I don't mean the specific attorney and the specific party. Instead, we're looking at classes of attorneys and classes of parties. So let's take, for example, Bayer Pharmaceuticals. So Bayer Pharmaceuticals is not specifically Bayer Pharmaceuticals. Bayer is a pharmaceutical, a medical device company that's international, that's listed on the stock exchange, and so on and so forth. And it's those types of companies that we would look for similarities between. And similarly, when it comes to attorneys, are they from a large firm, a small firm? How do we classify those firms? Where are they located geographically? So what we did was we took a hard look at what judges have done in the past. Now, there are two ways that judges' decisions are recorded. The way I think that most people are most familiar with it is opinions. That is a written decision by the judge that explains the rationale as to why they arrived at that particular conclusion. Judges draft opinions in fewer than 2% of cases that they have motions before them. So it's a very, very small data set and doesn't really tell you much about how the judge is going to rule in your case. The other 98% of the decisions are recorded only as grant and denial. I hereby grant your motion, I hereby deny your motion. So that information by itself is not very meaningful, because if a judge grants, let's say, for example, 70% of the motions, that of course does not mean you have a 70% chance of your motion to be granted, right? Past performance, as we're all aware, from any stock offering is not indicative of future results.
Right.
So what we did with those naked grant and denies, we wanted to understand the circumstances of those grants and denials. So again, was it a pharmaceutical company that's publicly traded or privately held? Is it international or is it based in the US? How large is the company? And so on and so forth. And then we wanted to understand who was on the other side. Is it an individual on the other side? Or is it a similar corporation of a pharmaceutical medical device? Who are they represented by? Is it a big firm or a small firm? Is it a solo practitioner or is it a plaintiff's firm? And once we enriched the data with that, we were able to then, utilizing machine learning to process it, as well as AI to understand it, to see patterns within those decisions. So it's no longer a grant or denial. Now it's a grant or denial with a whole host of other factors attached to it. So that was one piece of the puzzle. But the other piece of the puzzle is to understand who the judge is. So the way that we understand who the judge is that we look at their biography and their experience. So the obvious ones would be, where they worked. Were they in private practice and public service? Were they a state court judge before being elevated to the federal bench? Where they went to law school? But then we start doing deeper dives. For example, where they went to undergrad, the political affiliation, what is their net worth, geography, and so on and so forth. And we developed dozens of different characteristics that we apply to each judge. And by marrying those historic decisions with the biography, we're then able to predict with a high degree of accuracy what that judge is going to do based on the specific circumstances in your case, meaning, again, who the actors are. And then with that information, we can simply tell you how the judge will rule.
So how do you, that sounds like the subjective aspects of factual things.
Well, that's exactly right. It is subjective to some degree, but that doesn't mean it's not quantifiable. So it is subjective that the individual will ultimately come out different based on their particular propensities. But with enough data and the correct approach, you're able to look at and predict how that person will react to those factors.
So what do you end up with? Do you end up with a probability of, if we have this judge, we have this percentage to have this outcome, or something different than that?
So it depends on which type of motion that we're talking about. So first, let me just make sure that we're all on the same page as it relates to what judges do. So judges, for the most part, are there to determine law. They're not there to determine fact. The jury is there to determine fact, and the jury is not there to determine law. So if it's a legal question, the judge decides it. If it's a factual question, then the jury gets to decide which presentation of the facts is most compelling. So what we're talking about are those legal questions that come before judges, and those are in a variety of different types of motions. So at various points in the case, you can file various types of motion. Once a complaint is filed, that is, once a case is kicked off, the first type of motion that you can file is called a motion to dismiss. You can make a variety of arguments why the case should be dismissed immediately without proceeding to discovery. Discovery is, of course, the phase where you have all the things you see on TV, the depositions, looking at millions of documents, and so on and so forth. And of course, if you can kill the case before that's a huge win. If, however, on the plaintiff side, if you can survive a motion to dismiss and then get to discovery, a lot of times now you're talking about some form of settlement, whether it's the exact type that you want, but at least now there's a chance of settlement or some payout, because ultimately only less than 2% of cases actually proceed all the way to trial. So most of those will be decided during the discovery phase. And during the discovery phase, there's different types of motions that you can file. Some similar to a motion to dismiss, which is called summary judgment, which can also totally get rid of the case. And then there are others, like, for example, motion to compel. Like if you want a particular person to testify, you can file those types of motions. So there's a whole host of motions out there. So our predictive technology, we have two forms of predictions that we provide. One is a binary prediction. That is, it will be granted or it will be denied. And we have a threshold for when we determine it's a grant and when we determine it's a denial, and that's for the motion to dismiss. As it relates to,
what would somebody then do with that information once you have it?
That's a great question. So there's a couple of different things that you can do. And let me explain how the technology is used as well. It can be used in two different ways. So after a case is filed and a judge has been assigned, you're on the defense side, let's say, and you want to determine whether or not you should file a motion to dismiss. Now, you might say that's obvious, you should file a motion to dismiss because, hey, if you win, everything goes away. But if you knew with certainty that the motion to dismiss would be denied, then you've essentially shown your hand to the plaintiff side with no benefit, right? For a motion to dismiss, you list all the deficiencies in the plaintiff's complaint, and then hopefully the judge agrees with you and it says it should go away. But if you've listed all the deficiencies and you're going to lose, now what plaintiff can do is be ready for all those arguments and challenges as they come throughout the rest of the case. So that's one. Now, the other big piece, of course, is simply advising and counseling your client and being realistic about their chances. So most of what attorneys do, of course, they write briefs and do everything else, but really they're there as advisors and counselors. So you want to be able to give the best advice and counsel to your client. You could say, hey, the facts on this case are great, the law is great, but we ended up with Judge Johnson, and because we've used this predictive technology, we know she will deny this motion to dismiss. So let's be prepared for that. Let's start planning resources. Maybe we would use a different type of attorney to argue this motion. So that's one aspect that you might use it for at that point in time. Another way that we can do this is not necessarily waiting for a case to be filed, but because our technology does not look at the facts of the law, that is, our technology is entirely focused on the judge and the actors. So the facts and the law, in a way, for us are irrelevant for a prediction from a predictive purpose. So we can therefore deploy our predictions even before a case is filed, so long as we know who the actors are going to be, who the attorneys are, and who the parties will be.
So you don't even care what the case is, really.
Correct. We only care about the general nature of the suit, and that's it. So once we have that information, you can go ahead and plug it into our technology. And of course, you file in a particular jurisdiction, but you don't get to pick your judge. So the way that we deal with that, and that the judge hasn't been assigned, is we simply analyze every judge within that given jurisdiction. And we tell you what your overall likelihood, as well as the individual judge's likelihood of granting or denying that. Now, of course, from plaintiff side, that's crucial because now you know, hey, I have a great chance if I file in the Central District of California, and I have a really bad chance if I file in the Eastern District of New York. And you can make strategic decisions based on that. Now, it's not only on plaintiff side, even before a case is filed, the defendant sometimes has the right or the capability to transfer jurisdiction. So you file a case, and we had this with a client. They filed a case in the Southern District of Florida. It was assigned to a particular judge. They were representing the defendant, and they were contemplating filing a motion to dismiss. And we did our analysis, and we determined that she was not going to grant their motion to dismiss. It was a loser. But they had the opportunity, because one of the defendants was based in California, to transfer venue to California. So he went ahead and did the analysis in the Central District of California, and sure enough, they actually have a very good chance of having that motion to dismiss being granted. So now this is a case with tens of millions of dollars at issue. And by simply filing the motion for transfer and doing that, though, in a strategic and thoughtful way, using the technology and the predictive capabilities, you could actually totally wipe out the case at that stage just by having this intelligence.
Are the judges aware of this?
So there are some judges that are aware of this. I actually had a great experience. I was on a panel, and there was a federal judge who was recently appointed maybe 4 or 5 years ago by President Trump. And so the way that we test our technology, by the way, is accurate to close to 85% of the time. So our predictions almost 9 out of 10 times are correct. And the only input, as I said, is not the facts under the law. The only input the user provides is the case number. That's it. Put in the case number, you press the magic button, and you get your prediction. And the reason we know we're right 85% of the time is when we were creating our models, we wanted to use as much data as possible, ingest as much data as possible, because that's the way that you make the models the most accurate. But what we did when we were doing that ingestion, we randomly excluded 50,000 motions. So those motions were not part of the model, and the model had never seen those. And then once we created the model, we simply ran those 50,000 motions through our predictive technology, determined what our prediction was, and then compared it with the real world outcome. Because those
How did you ever come up with the idea of doing this?
Well, as an associate, as a young associate, I was once tasked with the project to analyze a judge, and as it related to a particular motion. So, I was at a big firm before I actually went to the Department of Justice, and the firm had a client, and there was a lot of money on the line. So I went ahead, and I was only supposed to look at the motions to dismiss for this particular judge. And sure enough, I go to the research, and you realize there's 10, and none of the 10 have any facts that are relevant to the facts at hand. Nonetheless, you're asked to do something, you write up the memo, and I remember how frustrated I was with this lack of insight into the person that will ultimately be, frankly, the only meaningful person involved in the case. And, fast forward, I was at a data analytics company, and I started getting a sense of the power of big data and understanding how characteristics are incredibly important in determining predictions. So the data analytics company did a lot of work in the intelligence community. And in terms of the way that the intelligence community works in identifying actors, they don't simply identify Dan's friends. Dan becomes a composite of a variety of different characteristics that I have. And then depending on how closely those characteristics match others, that's a way to identify potential connections. So understanding that the characteristics, as well as past activities, really are one approach to making these predictive determinations. That sort of got me the idea that, hey, maybe there's something out there that if we start looking at judicial biographies, if we start looking at other information, there might be an opportunity for us to actually provide predictions. And in some ways, you know how you get those creepy Google ads where you were just thinking about taking a vacation, and then it starts populating with, hey, are you looking for a hotel in St. John? And and you're thinking maybe Google's listening, which probably it's not. But the way that they do that, and they monetize this in the billions of dollars, is they have, if you will, two buckets that are relevant to us and our buying and our future buying, our predictive buying. One is what we've bought in the past. The second is who we are, right? where we live, our income, education, who our neighbors are, et cetera, et cetera. So combining those two components allows Google to place these highly targeted ads, predict our buying. So our approach is essentially, let's not predict buying, let's predict what the judge is going to do.
So does a judge ever come to you and say, I keep turning down all these motions. What's wrong with me?
I should have circled back because I didn't answer your earlier question about what federal judges think about this. So I was saying I was on a panel and I was describing our backtesting process. And before we were on the panel, I went ahead and analyzed that federal judge. And I looked at, his decisions and I compared them with all of our predictions. And it turned out we were correct 87% of the time with regard to his decisions. We're sitting there before the panel, and we're chit-chatting. And I'm like thinking, should I say something? Shouldn't I say something? And I went ahead and I told him what we did, and a bit nervously. And he turned and he said, "That is so cool." So he was totally blown away by it, and he wasn't at all intimidated by it because he also understands that while we're able to predict, that's not determinative. It's not like we're saying he must do that today or tomorrow. He still has, if you will, still free will and all the rest. It's simply that technology has gotten to a point that we can make these accurate predictions, but that takes nothing away from the human actor.
So if the judge had a bad night's sleep and he's got cranky kids in the morning, does that affect something or is that different?
Well, at the end of the day, 15% of the time we get it wrong. Now it's a very small percent, but that 15% potentially could be attributable to exactly some of the factors that we can't control for. Now, what's very interesting though, to go back to something else you said is, if we're looking at someone and they're totally outside the realm of normal, that is when we look at their decisional patterns. So that's where you get to something that seems to be outside of where you want to be, right? If we wouldn't be able to predict, if you will, what they're doing in 85% of the time, and it's much, much lower, then there's something wrong. Obviously, then their decisional approach is very different than everyone else's. And it's actually one of the things that I would think, one of the most high profile things that happens with the law is either the handful of Supreme Court cases that happen, a couple times a year, but it's a very small number, or judicial confirmations. And judicial confirmations, they answer this, highly detailed questionnaire. But really what we want to understand is, look, Republicans are going to appoint Republican-leaning judges, and Democrats are going to appoint Democratic-leaning judges. The real question, though, is within that bucket, are they within the mean or are they outside the mean? And by being outside the mean, it doesn't necessarily mean you hold a particular position on any hot button topic, abortion or school choice or whatever it is, because those questions rarely come up certainly at the federal trial level. Instead, what you want to know is if there's a normal contract dispute in front of them, are they going to act within a mean? And there is variation there. But what you don't want is someone that's totally outside and his or her decisions are just way out of whack. So that's where you might see variation. But what is interesting for us is that even with our approach of looking at the biographical information, we're able to do something which I admit even I've been surprised by. And that is, I've talked a lot about how we're focused on the judge and so on, and how we use their past decisions in some ways to inform our approach. Well, I always get the question, what do you do with newly appointed judges, right? You don't have all that rich data set. So that's where the biographical information really comes into play. Because what we do in that instance is we match the judicial biography of the newly appointed judge with other judges that have been on the bench for many years. And we use those judges as proxies for what this judge will do over the next 5 to 10 years.
Is that not being true?
And when we look at that, our rate of accuracy slides, but only in the most minute amount. It slides from 85 to 81%. So a judge that's just appointed to the bench, we're able to determine 8 out of 10 times what they're going to do tomorrow and the next day and the next day without them ever even without ever them sitting for any period of time.
So this sounds like a different version of the Dr. Phil stuff with jurors, of predicting jurors in advance, but it's a kind of a deeper dive, if you will.
Yes, it certainly is, and also because I think when it comes to jurors, people look at them as more subjective actors and more swayed by a variety of arguments, and judges are supposed to be these monolithic robots, right? And the reality is they aren't. And they are like any, they're like all of us. And certain things act as triggers for us. Certain things push us in one direction or another direction. And frankly, there's nothing wrong with that, I think. If you think about the way the justice system is set up, judges are not required to defer to their peers. Meaning, if one judge has the same case in front of them and another judge heard that case the day before in the same court, the second judge is perfectly and able, it's legitimate for them to come out to something entirely different. Which meaning that justice is not a single serve. Justice is human justice. It's not AI, it's not robotic, it's not necessarily God-given, it's human. And by allowing humans to make those decisions, we also, if we're being honest, have to account for variations. Now, what we've been able to do is use those variations to our benefit and create predictions. But variations and the human aspect of all this, I think is really what makes our justice system so interesting.
So is this commonly known in legal circles that this kind of technology is being used?
So we launched our technology last year in July, and we're starting to get some traction. We have in a variety of different contexts, whether it be law firms, whether it be insurers. There's a whole field of litigation funders that are funds that specialize in providing the funding for people involved in litigation or large operations involved in litigation. So there's certainly interest, and we're hoping to push that up. But
well, I'm just wondering if ultimately as an industry, I mean legal, if you want to call it an industry, it starts to adopt this kind of approach, whether it's yours or somebody else's, that basically using technology to this depth to predict things that just have never been predictable.
Yeah, I mean, I think it's like this for many industries. I mean, when you're talking about a massive merger and acquisition, they're trying to use predictive technology for, whether it comes to Netflix and what movie you're going to watch next. They're also using predictive technology. So I think many industries have started to embrace this. Law being, I think, generally conservative and slow moving, so it takes them a little bit longer to come around to that. But the interesting thing is that especially when it comes to big law, their clients are all these sophisticated corporations, many of whom are making almost day-to-day decisions using data analytics. I mean, I don't know of a single large company that doesn't have an analytics section to it. That they have people that their sole job, they have data scientists, statisticians, and the like, that for any major decision or even minor decisions, they want the data to come in, and they want data science and the technology associated with it to inform all their decisions. And there's no reason that the law, frankly, where there's money and even survival on the line, that you wouldn't deploy the exact same type of technology.
And do lawyers typically think like that?
No. Needless to say, I've had a significant amount of opposition, mainly coming from either people are, for the most part, it's not that they're tech phobic. It's simply that they don't appreciate the value of technology. They think that they can do this. They think they can tell you what this particular judge is going to do. But the reality is that they can't. And that's just a human limitation, that I can't guess what someone else is going to do because I don't have sufficient information. I don't know enough about them. I don't appear before them. Even an attorney that appears frequently before a judge, the judge hears probably dozens of cases a day. And if the attorney's lucky, he may have appeared before her 20 times in their career. So just think of how small of a data set they're using to make these assumptions. One of the more telling examples that I had was I was discussing the technology with a large plaintiffs firm. It's one of these plaintiffs firms, the way that you describe them within the law, it's like private jet plaintiffs firms, right? So they're making a lot of money out there. And they provided me with 25 of their cases that they had been involved in most recently, and asked to run our technology to see how our technology compared with the outcome in those 25 cases. And when we ran our technology and when we compared it to the actual outcome, so we were able to ascertain the correct outcome in 21 out of 25 instances, which is 85%. It's perfectly in line with our past back testing. But what was more interesting to me was that 11 out of the 25 this is plaintiff side, they had lost at the motion to dismiss stage. So that motion to dismiss stage is the stage that if they don't get past, they don't pass go, they don't make any money, all the money and time they've invested is a total loss. 11 out of 25 means basically this very sophisticated firm, it's almost a coin toss, whether or not these cases that they've vetted are going to go anywhere. And yet all 11 of those cases, we correctly anticipated that they would be dismissed based on the judge. So aside from correctly anticipating that, imagine if they had an alternative jurisdiction to file in, and that we would have identified that alternative jurisdiction as one that's more likely to survive that motion to dismiss. They could not only have avoided filing the 11, they could still file the 11 and make money on all those 11 if they had just simply selected the right jurisdiction and used the available technology out there.
So could you also potentially go to a very, say there's a very large money case going on, I mean extremely high, you've got a powerful law firm. Could that law firm then come to you and say, or the client come to you and say, what other law firms should we bring in to help on this? And then you analyze all the law firms against that case and judge and so forth?
Yeah, no, that's an excellent question. So again, it doesn't get to the individual. So I'm not going to be able to tell you with this technology yet whether or not, Mary is a better lawyer than John.
Oh, no, I was thinking of a firm, not person.
Firms, yes, but firms. So a lot of corporations have moved to a concept called panel counsel. Panel counsel is rather than going out and hiring an attorney in each and every matter, and they have sufficient number of matters, they put out an RFP or request for proposals, and they ultimately hire on the panel, let's say 5, 6, 10, depending on the size of the company, different firms. And that allows the in-house attorneys, the corporate attorneys, in any given matter to reach out to any of those 10 because they're already vetted. Now, when they select those 10 or 5, a lot of times it'll be a mix. So it might be a mix geographically, like, some are based on the East Coast and some are based on the West Coast, but sometimes it will be also like size and revenue and other attributes. So certainly in that instance, we can absolutely tell you which type of law firm will do a better job for you, or sorry, not a better job. They all do a great job. Which law firm will be most advantageous in front of this particular judge? You can absolutely do that now.
We're going to have to cut this. We can talk about this for hours. This is just so fascinating, but great stuff. Thank you so much. I hope you all enjoyed this episode. This has been eye-opening in terms of an entire industry. And thank you for listening to the Voices of the Internet of Things. And thank you very much, Dan. Appreciate it.
Oh, thank you so much, Chuck. This was a great conversation. I appreciate you bringing me on.